All rise. Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in the consolidated cases of CV16-0309 and CV16-0310, Jenkins et al. Versus Security Title et al. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and your client. Each side will have 20 minutes for argument, and Mr. Breen, as the appellant, you're responsible for watching the clock on the podium and reserving any time for rebuttal that you might desire. Please be advised that we've read the briefs and we have conferenced the case prior to argument, so we think we understand the facts and the procedural history fairly well. With those preliminaries out of the way, Mr. Breen, you may proceed.
Thank you. Good morning, Your Honors. I'm Dennis Breen. I'm representing the Mr. and Mrs. Jenkins, who are the plaintiffs in this matter. This case is about an unsophisticated couple that basically got managed or handled by a team of professionals that they were relying on. Dismissal of this case was in error. There are enough allegations and facts for the dismissal purposes of negligence, of breach of fiduciary duty, of securities fraud, of negligent misrepresentation to meet and to merit and sustain approval of the amended complaint. In fact, it was approved by the trial court for all of the defendants except security. So I don't believe the timing is an issue here either. Security's motion to dismiss, it was granted based on two things. That there were supposedly no allegations of fact, that security failed to comply with the provisions of the escrow agreement, and that the tort claims, quote, appear to be barred by the statute of limitations. I think both of those reasons are wrong. Security did not comply with its title commitment indicating a deed of trust for the Jenkins, nor did they correct it or cancel it. They did not follow their own conditions of title to verify the validity of Equity 253, nor did they correct it or do anything about it. Security modified a deed that they to change the legal description instead of sending it back to the Chicago where it came out of the estate. The combination of those things not being corrected are sufficient to say that they did not manage their escrow instructions carefully or with good professionalism. Also, on the tort claims, they're not barred by the statute of limitations because they constitute a breach of fiduciary duty, and escrow agents owe that fiduciary duty to both strictly comply, which they did not do, as we just discussed, and to disclose evidence of fraud, which again they did not do. And concealment of those tolls the statute of limitations under the actual knowledge standard, and the Jenkins didn't have that opportunity to have actual knowledge until they in fact walked into our office. The Jenkins were being managed by Ferris, and security failed to disclose what was clear evidence of fraud or a scam. They had an annuity issued and security without license or disclosure. The invalidity of the Equity 253 LLC. That Ferris was a principal in this, not an agent for investors. That the guarantee issued by 253 or Ferris guaranteeing their own obligation. These were all clear evidences of something was really awry in this whole situation. They gave them an unsecured 40-year payment without interest in the contract. Security's failure to disclose and reveal what Ferris was doing, which they clearly knew about since they inserted a CYA letter that has nothing to do with normal closing procedures. They aided and abetted his behavior and gave him a credence that he didn't deserve. And in fraudulent concealment, the duty to investigate really only arises when the plaintiff discovers the breach of trust, the actual knowledge standard being applied. And Jenkins was relying on Ferris. They were relying on the agent themselves to, when the payments were drastically reduced, which did happen, they went to Ferris to find out what the, quote, investors, not knowing it was Ferris himself, why they weren't paying. And so he lulled them into inaction until they became frustrated and, as I said, came into our office. You know, if the Ferris's, quote, trusted agent had been monitored by his broker, or if the attorney he theoretically engaged for the Jenkins, who never talked to them and was subsequently disbarred, had provided them with some advice, or if the hard money lender had required the corporation equity 253 to be transparent, or if the Wyoming investor who, quote, investor who went to Costa Rica had been truthful, or if security had revealed any of these items as it was required to do, then the Jenkins would not have ended up losing their property. Security could have withdrawn as an escrow agent or insisted on a review by counsel. They did nothing. So they aided and abetted in this process, changing a deed, signing. I mean, there's hundreds of allegations in the complaint that are regarding Ferris and what he did in this scam that they would have seen and been aware of and failed to disclose. Security proceeded to close knowing that the Jenkins did not have a clue what was being done to them and had not consulted with counsel. And that's a fact that's in this case. Security violated its obligations to disclose fraud that a reasonable escrow officer would see. That's a fact in the case. Security issued a title commitment and a conditions of title that was part of their obligations to confirm Equity 253 was valid or that a deed of trust would be issued, and failed to change, modify, or fulfill those requirements. That's a fact. Security participated in the issuance of a security in violation of Arizona statutes and their license instead of declining to do so. That's a fact in this case. Security knew or should have known that the Ferris was the only principal, not investors, and that the guarantee by the same entity or a person creating the obligation is a farce. That's a fact. Security failed to follow its own internal policies and procedures as required by statute to prevent fraud from hurting unknowing laypersons. That's a fact. These are all facts in this case. Instead, knowing this, they tried to escape with a CYA letter that just didn't have, that is a fact that was not adequate. We can and will prove all of these allegations in court if given the opportunity, and that's a promise. The number of allegations in the complaint were large, and they're not all against security, and most of them, in fact, were against Ferris and his actions and the failure of all the people around him to constrain him. But security, by not, and by their escrow officers seeing this stuff, clearly was wondering what was going on and wrote a letter to and asked the Jenkins at closing if they had seen counsel, and they said no, they hadn't. So they allowed, and that's their breach. They allowed this to go on instead of either canceling the escrow or saying we need to have somebody review this or having some monitoring process. And the other defendants as well. I mean, we have the broker that failed, the attorney that failed, the person that supposedly formed the corporation in Wyoming failed. Every part of it was a perfect storm of reliance by an unsophisticated couple on professionals who each just wanted to get their piece done. And it is that aggregation that caused all of this. That's all I have.
Thank you.
Okay.
Have time left for rebuttal if you'd like. You don't need to use it.
Good morning, Your Honors. David Laspaluto for the defendant security title. Your Honors, the Jenkins plaintiffs here agreed to enter an unsecured transaction, expressly agreed to sell their property without anything to secure their seller carryback loan. They were expressly and repeatedly warned of the risk of that type of loan. They were told repeatedly that they could seek outside counsel, and they agreed to that. And they opted to proceed forward anyway. And then they sat on that for 8 years before they sued, claiming that they didn't understand those items. Now, the Jenkins' true complaint seems to be that even though the escrow company warned them in writing about the risks of the unsecured loan, even though they agreed to it in the PSA 3, that security title should somehow have prevented them from entering the deal, or now we hear that security title should somehow have withdrawn. There is no such duty under the law for escrow. The Arizona Supreme Court in Berry has made clear that an escrow agent has no duty to regulate the transaction so that each party gets a fair deal, nor is the escrow company a guardian for the uninitiated. Plaintiffs are seeking, therefore, to expand the escrow duties beyond the state of the law. And with that as a backdrop, the trial court correctly ruled, granting the motion to dismiss and denying the motion to amend. And we would ask that you affirm those decisions. And as we work through, I think it's important also to note that there's a distinction between what was alleged as facts and what is stated as conclusions. Those are different things. So if we look at the motion to dismiss, this was properly granted for any of 4 reasons that the trial court set forth. So first of all, there was no breach of the escrow instructions alleged. Number 2, the statute of limitations. Number 3, the warning, the escrow addendum, would bar the claims. And then number 4, there was no allegation of facts that a reasonable escrow officer would perceive as evidence of fraud being perpetrated. So on any of those grounds, the motion to dismiss was in fact granted. Now, they actually dropped several of their claims in responding to the motion to dismiss. They dropped the implied covenant claim, the constructive fraud claim, the fraudulent concealment claim, and then the breach of contract claim. So in terms of no breach, Your Honors, that was the first ground for the ruling. Plaintiffs had not alleged breach of any escrow instructions. And that matches what the escrow agent's duties are, to comply with the escrow instructions, and then the other duty under Perkins and Berry to disclose substantial evidence, known instances of fraud. We'll get to that in a moment. But first of all, with respect to the breach, it was a fact that in responding to the motion to dismiss, the plaintiffs actually dismissed their claim for breach of contract. And in the opening brief, plaintiffs seemed to try to kind of resuscitate this claim a bit and claim that security title didn't do something under the escrow instructions. It's not entirely clear what. They do talk about these internal policies and somehow requiring a security title to determine the validity of an out-of-state entity under Wyoming's LLC laws. There's no duty, contractual or otherwise, to give legal advice and verify whether an out-of-state company was correctly formed under that state's statutes. And in fact, the escrow instructions specifically said, to which the Jenkins agreed, these were the instructions themselves, that Security Title was not going to do that, was not going to give legal advice, was not investigating the identity, authority, right of persons executing documents. That was Exhibit 15 to the complaint, paragraph 11. So whatever these internal policies allegedly may be, it's not clear what they are, but there's no allegation that those were somehow incorporated into the escrow instructions or could create some sort of extra escrow duty. And in fact, plaintiffs ultimately lost on that very issue on summary judgment as to the Sandlins. The court determined that plaintiffs were stopped from arguing that Equity 253 was not validly formed and that it was in fact a valid entity. So that takes care of the court's first basis for the motion to dismiss. The second, Your Honor, the statute of limitations here was clear. It was 2 years. There's no argument about that. And the facts are clear on their face. The transaction closes in July of 2006. At this point, the facts are made known to plaintiffs in the PSA 3, in the escrow addendum. All the things that they're claiming now are things that were disclosed to them at that time. That it was an unsecured transaction, it was risky, they may not be able to get back their money in the case of a default. So then plaintiffs wait until July 2014, more than 8 years later. And in fact, even counting the so your damage is right then. You don't have a deed of trust, even if you thought maybe a better deal would have been that, or that Security Title somehow had some duty to get you a deed of trust. You certainly didn't have one as of the close of escrow, and the documentation clearly said that. But even if we count from the date of the breach begins to happen as to the loan itself 2 years later, August 2008, which again is 6 years before the suit itself is filed. So under any of these analyses, the statute of limitations would have been barred. Now, plaintiffs raised two arguments here. I want to address them because neither one of them can save them from the statute of limitations. The first one was concealment. Plaintiffs do not allege any concealment by Security Title. All these allegations are about another defendant, and that is critical under the cases that specify that to toll the statute of limitations, the defendant himself must have taken the concealment. Second of all, though, Your Honors, the plaintiffs didn't allege concealment of the things they sued on by anyone. The documents that plaintiffs signed disclosed all those issues. The only concealment seems to be that certain payments were made on the loan over the years. At a certain point, it was only a very nominal amount. Plaintiffs needed to do no more diligence than just read what was in front of them. And a party is charged with knowledge of the terms of an agreement he signed. So that takes care of that concealment argument. Next, plaintiffs argue an actual knowledge standard. Two issues with this. First of all, plaintiffs did not assert this issue in the trial court on the motion to dismiss, which I'm addressing first, or even in the motion to reconsider that, the granting of that motion, therefore waived it as to the motion to dismiss. But it ended up being irrelevant in any event. Plaintiffs are complaining about the unsecured nature of the loan, but that was known to them. They also knew that Farris had a financial interest in Equity 253, and they knew in August 2008 that the loan terms had been breached. There was simply nothing more for them to know. Now, the third ground, Your Honor, was this escrow addendum, which is a disclosure and to some extent a waiver. The trial court was correct that any of their claims would be barred on the face of the pleadings themselves. Plaintiffs had been warned about the precise things they were suing about. Security Title made an express disclosure. Plaintiffs agreed to it. It was on a single piece of paper that in bold said unsecured loan agreement. So plaintiffs agreed expressly. They were fully aware that the loan was unsecured, that it was that this was of a risky nature, and that they had the opportunity to consult an attorney in order to review documents. That simply matched the warning in the PSA 3 that they had already agreed to, which said there was risk. I believe that paragraph is entitled risk, and it's not secured by real property. If there's a default, plaintiff's ability to collect may be severely limited. Plaintiffs also agreed that Ferris had an interest in equity 253. And in fact, at oral argument on that motion to dismiss, plaintiffs' counsel admitted we get to take their agreement to that as true, that they knew the loan was unsecured. That's in my appellate brief at page 21. And this amendment, this addendum, is really in keeping with the escrow duty. It's not security title's duty to make sure plaintiffs got a better deal or to police the transaction. The duty is to make a disclosure and allow people to proceed as they will. This is an enforceable, also as a waiver under the 1-800-ACATIO case. There's no public policy against enforcing such a disclosure and waiver where you disclose what the risk may be, and then you say, look, we're not liable or responsible for you taking that risk. You choose to undertake that risk. Finally, Your Honors, the fourth ground was that there was no evidence of fraud for a reasonable escrow officer. The duty here is to disclose facts actually known to the escrow agent that present substantial evidence of fraud. And you need more than conclusory allegations on this. It's simply not a fraud if the facts and risk are disclosed to you and you then agree to them. Plaintiffs argue the fraud was in the risky nature of the transaction, that it was unsecured, that Ferris had an interest in the buyer. These were all known and disclosed to plaintiffs. So ultimately, plaintiffs' complaint is that security title didn't stop them from entering a risky business deal, but that's simply not the duty of the escrow agent to kind of weigh who's getting the best deal and try to stop them. So, Your Honor, for all those reasons, the motion to dismiss was correctly granted. Now, as to the motion to amend, Your Honor, clearly the standard here is abuse of discretion, which we've cited in our answering brief. There's no response to that, so I think we're in agreement that that is the correct standard, and we cited cases on that point. And the trial court has the discretion to consider what is timely as to particular defendants. Now, keep in mind that by the time that plaintiffs actually filed their motion to amend, not only had the motion to dismiss been granted, the ruling had been filed. Securities title's final judgment was pending at that point, was unopposed. Its motion for application for fees and costs was pending and was unopposed. And this was almost 2 months after the motion to dismiss ruling had already been filed. And in fact, if we look at it, the complaint itself was filed in July. Now we're all the way into January 31st when that motion to amend finally gets filed. In fact, the trial court actually entered the final judgment just a few days after the motion to amend was filed and then gave a chance for briefing and ultimately amended the judgment to account for fees and costs in connection with that motion to amend proceeding. And plaintiffs provided no reasons for their delay. The complaint had been on file since the previous July. There was no request in their response to the motion to dismiss or at the hearing for that. And under those grounds, Your Honor, it was within the trial court's sound discretion to determine that this was not timely as to security title. Now, so on that ground, that would be affirmed. But also, Your Honor, the court held that the amendment would have been futile as to security title. And so what the parties there were arguing about were some issues that already existed as to the statute of limitations, and then the escrow amendment or addendum warning of the risk, but then some additional new issues that the parties were arguing about. So regardless of any new issues, the motion to amend suffered from the same statute of limitations issue. We had a 2-year statute of limitations. There's no ground for somehow going outside of that, and I've already discussed that. And then the same issue with the escrow addendum or the warning. That satisfied any duty under the facts of the case. The trial court had already determined that issue, and so on that ground, this was futile to try to amend, and there wasn't anything added that would have addressed that or changed that. Now, in terms of new issues, Your Honor, plaintiffs for the first time raised this title commitment. They also raised this new securities fraud issue. And then there was also briefing on the economic loss rule. So those three issues were in addition. So plaintiffs, on this title commitment, they get a copy of a prior title commitment based on PSA number 1. They get it after the close of escrow. They claim somehow that supports a claim. First of all, not raised in the complaint, only raised in the motion to amend. Second of all, if plaintiffs thought they were owed something under this title commitment, they long ago blew that statute of limitations. Number 3, Your Honors, critically, it's not relevant. It's simply a red herring. It's kind of a misunderstanding of what a title commitment is under the law and what this title commitment specifically said. So, first of all, it didn't matter because PSA 3 and the escrow addendum already told plaintiffs they were not getting a deed of trust, and that's already pled in plaintiff's complaint, amended complaint, in the attachments. They were not getting a deed of trust as security. Their loan was risky. Getting a commitment later that referred to them as a proposed insured if certain terms and conditions were met didn't change that. Now, as to the nature of a commitment itself and the misunderstanding here, a commitment under the law, under the statutes, under this court's decision in Centennial Development, for example, the commitment is not a representation. It doesn't say that plaintiffs are entitled to or owed a deed of trust or a policy. By statute, it's an offer to insure if certain terms and conditions are met. And here there was nothing to insure. Plaintiffs had no deed of trust. They had already signed things saying they were not getting a deed of trust. Commitment refers to them as a proposed insured if a deed of trust ultimately gets approved, executed, and recorded, and there was simply no such instrument. Those are the commitments requirements 1 and K that say that those are conditions to you actually getting a deed of trust and getting a policy. And then on top of that, Your Honors, as discussed in our brief, the Jenkins didn't pay for any policy, and the settlement statement shows that. It specifically shows, and this is the complaint Exhibit 8, I think it's the same exhibit for the amended complaint. They didn't pay for any settlement, they didn't pay for any policy. It specifically says that Sandland gets a lender's policy, not the plaintiffs. And there's no allegation that they ever made a claim on a policy or that they were somehow entitled to a policy. So that takes care of that issue. The securities fraud claims, Your Honor, there was simply no basis for a securities fraud claim. 4 reasons, really. First of all, barred by the statute of limitations also. Second of all, this was the ordinary course of securities titles business, which under the statute negates that claim. Third, it was simply inadequately pled. The elements of it were not pled properly. And then fourth, there was simply no falsity based on the warning that had been given to them. So first of all, obviously the statute of limitations, again, a 2-year statute of limitations. So if they had a claim under this, that was barred. And then if we look at the allegations themselves, there's no allegation that security title itself sold a security. So the liability could only be based on participation in or inducement of the unlawful sale of a security. But under the participation statute, if you are acting in the ordinary course of that person's professional capacity, you can't be deemed to have participated under that statute. There was no allegation to the contrary. This was securities titles, ordinary business, acting as an escrow agent, processing a real estate transaction and a loan transaction. Carryback loans are standard. And so under any set of facts, security title can't be held liable for the securities fraud allegation. Third of all, the participation in or inducing statutes have specific elements that can't be pled, warrant pled. You're required to plead specific facts of participation and inducement, not just these conclusions, which is all the complaint had. The facts actually, as alleged, are that security title actually warned the plaintiffs of the risky nature of the transaction. The inducing requires overcoming indifference, hesitation, or opposition, usually by offering consideration, persuasive advantages or gains, that sort of thing. The allegations on their face were that that security title had done the opposite, had actually warned them. And so that brings me to the final problem with the securities fraud claim, and that's there wasn't a falsity. The falsities that they're claiming are the same ones that they were in fact warned about and had expressly agreed to. Finally, Your Honor, the issue that was discussed in the briefing on the motion to amend that could form another basis for affirming was the economic loss rule, which prevents parties to a contract, as in this case, from asserting tort claims seeking the purely economic damages as opposed to damages to a person or property. And that policy is to simply uphold the parties' expectations. Here, the parties have a contract that sets forth their expectations. That would bar the negligent supervision claim, that aiding and abetting claim. Plaintiffs really are seeking purely economic damages for alleged failure to perform obligations as an escrow agent, which is the precise subject of the escrow agreement, which would bar the tort claims. Plaintiffs raise the Flagstaff case, but that's not really on point here because security title isn't contracting away its fiduciary duties. When an escrow agreement is in place, the plaintiff's remedies are limited by the economic loss rule to breach of the contract and then breach of the fiduciary duty, specifically following the terms of the agreement and then disclosing known facts that a reasonable escrow agent would perceive as substantial evidence of fraud. And I cited two cases on this issue in the escrow context based on the economic loss rule. One was a Good Time Rental LLC and the other was Sarsfield. And plaintiffs did not cite any contrary cases. So I think that applying the economic loss rule in the escrow context would be in keeping with court-specific limits on escrow duties. So, Your Honor, we conclude by saying the judgment should be affirmed. The Arizona law is very clear on escrow duties and their limitations. Plaintiffs really want to change the law of the escrow duty, expand it to make the escrow officer the police of the transaction. There's no escrow duty to inform parties about the inadequacy of the terms or of the transaction, to kind of weigh them and decide you shouldn't enter this transaction. Under plaintiff's proposed new standard, every time a buyer or seller later decides they didn't get a good deal, they could then sue the escrow company and have them on the hook. Thank you, Your Honors.
Thank you. Yeah. Rebuttal, Mr. Breen?
Several things, Your Honor. First, we're not in an argument today with respect to the allegations in the complaint and all of the factual issues that have been discussed, because they are deemed facts when on a motion to dismiss. They are agreed facts that there was inadequate notice by security, and that security also was in the, for example, on the economic loss, in a breach of fiduciary duty, there is an exclusion for that, and they they did breach their fiduciary duty when it's looked at with respect to the amended complaint. And I agree, the amended complaint was filed, and it was filed to clarify. As far as we initially thought, the complaint that we had did outline and was sufficient enough to explain all of the various issues that occurred. And then the trial court felt that it was not, so we amended the complaint to clarify those issues and added more activity as to what things had happened. These are things that we were looking to get the opportunity to show at a trial. The amended complaint, when we did the motion for reconsideration on the amended complaint and went through all of these, we received no response from the trial court other than denied. There was no explanations. There was no further explanation other than the ruling back that prior December. The security has an obligation and has a fiduciary obligation when it sees all of these activities going on, and that is in the statute. They're supposed to create internal policies in order to monitor their employees to make sure that their employees have guidance on identifying scams when they exist, and then making decisions or going to upper management, however they would provide for that, to either disclose that those are the things that are there, and they're both laid out in the amended complaint, and they're, for the purposes of the arguments here, I believe they're deemed facts, that their notices were inadequate, that they failed to to provide any kind of reaction that they are supposed to as a fiduciary, not just as an escrow agent. Because once there's enough activity going on, that's what the statute's about, is once there's enough activity going on that a reasonable escrow officer would say this is a scam, that's when they have this fiduciary duty to step in and to say that they need to do something. And that's where they failed. They didn't step in and say they need to do something. And that obligation is there to protect the couples exactly like the Jenkins, that are unsophisticated, that are relying on an agent, that are relying on that escrow agent, that are relying on the attorney, they're relying on these various people to give them advice, and none of them stepped up, including security. And so security has that same kind of obligation on it. We're not expanding at all what their escrow requirements are. Any escrow officer today who sees that kind of activity should withdraw from it, or should disclose it, or take some activity that makes it clear to the other side as to what's going on. We did allege the breaches of fiduciary duty in the amended complaint, and we outlined them as scams. We did deal with a motion for reconsideration to give all of that information to the trial court, and received no response on it. So I believe that they are not barred by the statute of limitations, because it does become an actual knowledge standard when they are being handled that way, and they don't find out what they came into our office to foreclose on the property because they were frustrated. And it was at that time that went through that agreement with them, and they found out. So this is not and that's what we put in the complaint. All of their notices, all of the information they were given was clearly inadequate to them, and security, as one of the participants in this, was required to have disclosed that. Thank you.
Thank you. Thank you for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned.